Good morning, everyone, and welcome to our very first morning blend of 2024. Incredibly hard to believe. We are thrilled that you've taken the time this morning and carved it out to spend an hour or so with Lori Armstrong and myself. Welcome, Lori. It's so great to see you again.
Nice to see you, Alison. Thanks again for joining us and putting this together.
For those of you that have joined us today for the first time, welcome. For those of you that have attended a morning blend in the past, welcome back. As you may know, that we do these about 4 times a year, and our focus is really on what are the things that our business leaders, our HR professionals, and others in the organization who are interested should know about what's happening in the HR space and the legal space. So we've had a couple of things pop up since we sent out the actual invitation for this particular webinar. So we've added some things in that we think you'll find of interest. As always, we will be recording today's session and we'll send a link out afterwards. So if you're not able to stay the whole time, or if you know someone who may have an interest in hearing what we're talking about today, please feel free to share that. Your questions are very important to us, so please use the question answer feature. Lori and I will do our best to address those questions, and if we can't, then we will certainly follow up, or you feel free to follow up. Our contact info will be at the end of the session. And we're going to be moving rather quickly through the first section of this, our legal updates. Lori has an unexpected event. And Lori, I don't know if you want to take a moment and share with our listeners a little bit about what's going on today.
Sure. So I'm actually attending a union election today for one of our clients, and it was supposed to be last Tuesday, and shockingly, it got snowed out. So they're doing the vote today, and have to be there to make sure that everything is done properly, and then to check the tally and all of that. We're going to talk a little bit more about labor stuff in just a minute, but I wanted to mention it because this is such a hot area right now, and this was a very small employer with only like 30 employees total, and an employer, frankly, that's very progressive. And so I mention it because no one is immune, and I'm seeing more and more and more activity, really sort of grassroots activity by particularly younger workers, and they have sort of an ideological belief that unions are a great thing, and it's catching a lot of smaller businesses off guard. So we'll talk a little bit about that in a few minutes.
Great. Just for those of you that may not have joined us before, we're going to do some quick introductions just so you know who we are. I'm Alison DiFlorio, and I am one of the co-leaders of Exude Human Capital. My work is really with organizations of all sizes in all sectors around all things HR. And what I hope to share with you today are some of the trends that we're seeing, some of the things we know HR and business professionals are going to need to be focused on in the upcoming year. And Lori Armstrong with Fox has been our partner for, gosh, Lori, 3 years now.
Oh, I think it's like 4. Didn't we start this before the pandemic?
It's been a while.
Yeah. So, and I have been practicing exclusively in workplace law for a long time. And in my spare time, I corrupt young legal minds as an adjunct professor at Temple Law School. And I also serve as a pro bono mediator with the EEOC. So love this area of law, and so happy to be able to provide the legal perspective and then partner with you for really the practical nuanced discussion that we have together. So it's great to be here.
Great. We do normally do a lot of this kind of together. Because of Lori's tight timeline today, Lori may need to be dropping a little bit early. So we're going to let her share all the legal updates, and I might save some of my commentary for after her departure, but we hope to get through all of these in the time we have today. So we do have some update. Whoops, we went ahead there. We have some updates on the independent contractor ruling. We have the State of the Union. We'll talk about that in just a moment. The EEOC's target enforcement plan, some legal implications for AI. We're going to talk about AI from the legal perspective because we're also going to talk about it from the HR perspective and how we're seeing it work well and where there are some landmines. And then it's election season, everyone. So get ready, strap on your seatbelts for that. The Daily Brew is going to focus on AI. Are you ready? And the topic that just won't seem to ever leave us, which is return to work or return to the office again. So we spoke about that when we our last morning blend. However, it still is a thing, and our employers are still dealing with it. I'm sure many of you on this call are dealing with it. So we'll talk about what we've learned, what the updates are, and what you can do to be prepared. Okay. So Lori, without further ado, you want to talk to us about the IC ruling? Oops.
Yeah, so go back one. Independent contractor rule. This has been out and about for the past 3 or 4 years. I think there was a rule that was proposed, obviously, in 2021, and then that was subjected to a legal challenge. But ultimately, the Department of Labor published a final rule on January 9th, 2024, which rescinds the 2021 rule, which is why I'm always going to have a job because this keeps happening. But basically, it defines who an independent contractor is versus who an employer is. And this matters for things like companies' obligations for payroll, timekeeping, for wage and hour purposes, and other things. And I should point out that this is the Department of Labor's definition. Independent contractor issues come up in other contexts, and they may have a different rule. So this is only for our wage and hour folks. But essentially, this creates a 6-factor test looking at the worker's opportunity for profit or loss. If you hire a painter and he's sort of managing his own affairs, then he's more likely to experience profit or loss. Whereas if you're somebody's getting paid the same amount all the time, no matter what, that's not going to be a thing. Investments by the worker and potential employer, the degree of permanence of the relationship. Is it a part-time, not part-time, but a temporary thing versus a more, the type of work, is that something that goes on all the time? The nature and degree of the potential employer's control over the work. Did you just say, hey, do this task, and they're figuring it out on their own, or are you giving them day-to-day instruction? The extent to which the work is integral to the potential employer business. Is this what the company does, or is it something that's ancillary, that's not part of the core business? And the worker's skill or initiative. I know that lawyers and maybe some HR folks like to get into like, oh, this is a big change. And yeah, it is a shift, but I've always said the independent contractor analysis is sort of like, if it walks like a duck and it talks like a duck, the fact that you call it a goose does not make it a goose, right? So if it's going to look and feel like an employee, it's going to be an employee, even if you try to call it something else. It's not how you define it. It's more a matter of what the worker is doing and what their relationship, how integrated their relationship is with your business.
So time to kind of take a step back, everyone on the call here, and take a look at those roles that you do have classified as independent contractor today, and put it against this new test and see, to Lori's point, if it still looks like a duck.
And I should say, it's one of the areas that there's the Wage and Hour Division likes to litigate, and they can come up with some significant awards if you misclassify somebody, because things like overtime become your obligation if they're an employee, and that adds up, especially if you've misclassified a group of employees. All right.
And employee benefits, et cetera. So
yeah,
it's definitely costly.
State of the Union. Okay, so this is just some statistics that union petitions have increased by 60% since 2021. I think I've said on numerous of these webinars that COVID combined with all the things that came around around that time kind of created the perfect storm for an increase in unionization. That, coupled with that the Biden administration, this is not political, he has said this outright, has positioned itself to be the most pro-labor administration that we've ever had. And we're seeing that. We're seeing that impact. Unions are winning at a near record 76% of the elections that are held. And in fact, and you'll see in the last bullet point, I referenced the Cemex case and that there were new election rules that were implemented in December, and they're expected to have a significant impact on these unionization rates because the opportunity to educate or campaign or explain or dissuade once the petition comes at this point is like 10 days. It's not several months. Everything has been really compacted, and this Cemex case is the one that really facilitates and encourages unions to gather their majority support and then come to an employer and say, we have more than 50% of the workers who signed this, and we want you to just voluntarily recognize us as a result. I could spend an hour and a half on the Cemex decision. I won't. But really the point is that you have to be paying attention to what's going on in your workplace now, because I usually do this with an iceberg, right? And you see the top of the iceberg is here, and then all of the rest of it is under the water. Well, by the time you get the petition, the demand for recognition, all of that organizing has grown under the water, and it's too late. A couple other points I wanted to make, just because I think it's interesting that we're seeing an increase in unionization, particularly for Black workers, but people of color, and non-union workers do have a median, this is according to the Bureau of Labor Statistics, have a median weekly earnings that are 80%, 86, I'm sorry, non-union workers make 86% of earnings versus union members. Now, their statistics always can be skewed, but this is a statistic that can be used to tout and encourage unionization. The other thing that we'll note is ULP charges. Those are violations of the National Labor Relations Act. That act applies to both union and non-union workforces. And so even if you're not unionized, if you are taking actions or have policies in place that tend to stifle workers' ability to engage in what we call protected concerted activity, to talk about things like safety, wages, other things, other terms and conditions of employment, that's considered an unfair labor practice charge, or ULP. Well, we've had a 10% increase over last year, and that last year was a 19% increase over prior years. So all of this activity is really going up. And whereas in the past, and you've heard me say this, and some of you might be going, I know we keep hearing this, but it's not where any employer can feel safely like, I don't have to worry about this. And I also want to state that, let's go to the next slide.
Okay.
This will show you union win rates as of, this stuff it was just supposed to be the slide. Doesn't matter. Anyway, this stuff at the bottom shows you the union win rates, and the percent won by the union is pretty high. Our RD petitions are those petitions which are pretty rare, in which the union is, the workers have said they don't want a union anymore. It's called a decertification petition. And so you kind of skip that one. The other two, the RC and the RM, depends on who files it, whether it's the employer or the union. But in both those cases, the union win rates are very high. As I was saying, you sort of can't ignore it. And I'm not touting myself, although you are welcome to call me. But if you have any concerns or want a better understanding, please contact an experienced labor practitioner. It is a different skill set than regular employment law or regular corporate law or other areas of law. And while those folks may be excellent at whatever area they're practicing in, labor is very nuanced, and you can easily get it wrong because it's very it's like bizarro world. It does not work the way you expect it to.
The only thing I want to add here too, and I know you've heard us say this before, but this can impact for-profit and nonprofit organizations. In the Philadelphia region, we're seeing quite a bit of activity in the not-for-profit sector. And to Lori's point earlier, the size of the organization doesn't seem to matter much. So just if you're a small organization, you just want to make sure you don't take your eye off the ball of the things that matter to employees. if you want to remain non-union. So just it's an important time going into a difficult year, a challenging year. People are requiring employees to come back to the office, those kinds of things that are impacting working conditions. So just be aware and contact Lori's brain, a labor attorney, if it should so arise.
Happy for you to contact me, but I'm not the only one in town. So just make sure it's somebody. Okay. In a different federal agency, the EEOC has come out with its targeted enforcement plan. And this is really where it lays out what its initiatives are over the next several years. And usually what that means is this is the area where we will see them paying more attention. So if they get a charge filed by an employee who believes they've been discriminated against based on their religious faith, particularly either because they're Jewish or they're Muslim, or LGBTQI protected status, the EEOC is going to pay attention. Not that they don't pay attention to other charges, but this is an area that they're really focusing on, and they want to make sure that that those are well investigated, and that if there's any discrimination going on, that they correct it. They also want to increase access for vulnerable and underserved workers. These are workers that maybe aren't aware of the EEOC or the law, that maybe don't have a clear path to access. And so there's a big education component in the targeted enforcement plan. The EEOC is also looking at workers who are affected by pregnancy, childbirth, or related medical conditions, particularly under the Pregnant Workers Fairness Act, which came out last summer. That is another amendment, essentially to Title VII, that complements the Pregnancy with Discrimination Act, which requires that employers provide reasonable accommodation to pregnant persons in the workplace. The idea being that, similar to those workers with disabilities, that you can still be an engaged, productive person in your workplace. We just might need to modify some things. And the idea is to be inclusive and engage those individuals. The EEOC is also looking at employment discrimination associated with the long-term effects of COVID-19. And I know Alison's going to talk quite a bit about AI, and I'm going to talk a little bit about it, technology-related employment discrimination. That is one of the areas that they're really looking at. They are also looking at underrepresentation of women and workers of color in certain industries, construction and manufacturing, finance, tech, science, technology, all of those fields where we tend to see a higher population of men. The EEOC wants to understand, why do we have an underrepresentation? Is that a systemic issue? Is it intentional discrimination? And what can we do to address that? Also, as I said, recognizing employers' increased use of technology to make or assist in hiring or other employment decisions. I'm going to talk more about that in a moment. And then lastly, and you've heard me talk about this under the National Labor Relations Board as well, and the General Counsel for the NLRB, overly broad waivers, releases, non-disclosure agreements, non-disparagement agreements when they restrict a worker's ability to obtain remedies for civil rights violations. Now, you may remember that the McLaren decision came down last March. That was an NLRB decision, and then subsequent guidance by the General Counsel that really restricted confidentiality and anti-disparagement provisions in severance agreements. It's the same idea that the EEOC is looking at here, where your agreements say things like you can't talk to anybody at any time about anything work. That's going to be viewed as overly restrictive and infringing on, in this case, an employee's right to assert themselves under Title VII or the other discrimination statutes. This government agency also wants workers to be able to talk about their discrimination that they may have been subjected to, and to be able to provide that information in the context of investigations or in the context of assisting another worker who might be experiencing something similar. We've certainly seen at the state level, particularly in New Jersey and in California, restrictions against broad confidentiality or confidentiality at all in sexual harassment cases, for example. So this, I think, is a trend. And then, of course, we've heard on the federal level that there is a movement to do away with um, restrictive covenant agreements as well. So all of this area is really shifting right now.
Lori, just to that point, I know that we've received many questions over the last several months around the non-disparagement agreements within severance agreements. Can you speak a little bit about just generally what the language can or should not include in a severance agreement with regards to disparagement?
So non-disparagement is never going to be okay because they consider it to be too broad. You can have a prohibition against defamation. And so you can, which by the way, an employee doesn't have the right to defame you anyway, but I still think there's value in including that type of language in an agreement because it's a reminder to the employee that if they are defaming, and defamation is a higher standard, right? It is speaking an untruth that casts someone in a negative light and causes reputational harm, as opposed to disparagement as like you say something not nice about me, but I don't have to prove all of these other hurdles to establish it. So the language should be about that the employee cannot defame the employer and or specific individuals within the employment, and contains some sort of language about it can't be with the intention of or impact of causing reputational harm or things like that. If anybody, I don't have them in front of me, but I do have some clauses that I have used that I've actually gotten approved by the National Labor Relations Board when I've done an agreement with them, and I'm happy to provide them. So if you want to reach out to me, I'm happy to assist.
Great, thanks so much for that clarification.
So the use of artificial intelligence. Okay, so so the EEOC and a couple of other government agencies actually came out and did a position paper and acknowledged that our existing laws do create protections in this area, and we just have to think about the way they're applied a little bit differently. And so the EEOC came out with some specific guidance and has instructed that employers need to audit your AI tools if they significantly contribute to employment decisions, to ensure that they're not discriminatory. And so there's two types of discrimination under the federal laws. There's disparate treatment and disparate impact. Disparate treatment is where you sort of know what you're doing, right? I'm intentionally not hiring someone because they're a woman or because they're Black or because they're Jewish or because they're gay or whatever, right? Versus having a neutral policy that disproportionately impacts people of a protected class. That's disparate impact. And what the EEOC is most concerned about is where you're using some sort of AI tool that has that disparate impact on a particular protected class. So a test that, and we've heard about this in the context of SATs or other, they're not AI tools, but in terms of other testing, that it might have that Black students, for example, statistically don't perform as well on those types of standardized tests. And what is the reason for that? Partly it's systemic because of the language and the way things are written in the test. Well, similarly, some AI might have that sort of disparate impact on a particular protected class. And so if you have to, one, check your tool to see whether or not it's having a disparate impact. And if it is, you want to make sure that that tool is job-related and consistent with business necessity. So, one of the things I think about is, and I don't know if anybody's a football fan, but the Wonderlic test that they use for football players, supposed to measure intelligence, I guess. I'm never really sure how that relates. I've seen some of the questions, and I don't see a tie between being good at football and passing that test, right? And what they're looking for is the test really related to the tasks that are going to be performed, or is it just sort of a generalized test? The closer the tie between the test and what they're actually doing, the better off you are. The more distinct they are or unconnected, it's going to be harder to establish that the test is job related and consistent with best business necessity. You also have to show that there's no less discriminatory alternatives that are equally effective. You're not shielded just because you use some sort of outside vendor, right? So it's not enough to say, I'm going to contract with the ABC company and they're going to do all this testing for us. If it's discriminatory, it's their fault. Well, they're your agent in that context. And so you won't be shielded. Basically, that the EEOC is looking for this 4/5 rule, that there should not be more than a 20% variance in the selection between members of the protected class versus others. And that sort of is your, ooh, if there's a greater than that variance, then that suggests that there is a problem with the test. The EEOC, go ahead.
No, I was just going to add in there, because I know you talked about having if somebody's doing your hiring for you, for example, then they're the third party agent, but your software that may have AI embedded in it to make these selection decisions or to push forward the resumes that may meet certain criteria, that could also fall under this piece as well, correct?
Yeah, that's exactly right. So just because you're using some sort of third-party software, you can't blame the test.
Right. And I know New York City last year came out with mandatory reporting to be located on your website for my understanding, for job seekers to be able to see with regards to certain data. I don't know, Lori, and I don't know how many people on the call are from that area, but if high level, if you could just share a little bit about what the reporting.
I can't actually, because one, because I don't think I have time, and two,
got it.
I think you covered it sort of broad strokes. I am happy to talk to anybody at any time offline about the specifics, but there are other states that also have similar requirements. Illinois, I'm trying to think, there are a few others, but basically there's sort of there's some scrutiny around what you're doing, and that you have to notify applicants and workers that this is it's kind of like a fair credit reporting sort of.
Yes.
So yeah.
Okay. And I know you're pressed on time here, so take it away. Whoops.
Go back one more.
Okay. This last one. Sorry. It's
so
on
similar
auto.
to the disparate impact, which relates to Title VII claims, there's also implications under the Americans with Disabilities Act. And there are 3 ways in which you might have an AI tool that could violate the ADA. One would be a failure to accommodate in lieu of AI. So if someone, for some reason, can't participate in whatever the AI process is, other issues relate to screening out a candidate with a disability who can perform the essential functions of the job. But the AI tool screens out a specific function and then basically disqualifies somebody. But there might be an accommodation that would allow the person to perform the job, even if they can't perform this particular task. And lastly, conducting disability-related inquiries or medical examinations that violate the ADA's restrictions. There might be a tool that you use that seeks information that you can't seek until after you've made a job offer. And the ADA prohibits, for example, that you do any sort of what they call a medical examination pre-offer. There has to be an offer made. That does not mean that you can't inquire about somebody's ability to perform job functions. It's just that as advanced as AI might be, there is this opportunity for some things to slip through the cracks. And so you are going to want to build into whatever your AI process is. I'm going to call it an appeal mechanism for lack of a better word, but some opportunity for the applicant or employee to either ask questions or challenge the result, so that you can make sure that you've not improperly excluded somebody based on an AI result alone.
That's really very, very interesting. And Lori, I know you have to jump. Are we at your hard time right now?
I have like a minute or two and then I got to jump. But.
Okay, so I just want to say, based on what Lori just shared, before you introduce any new tool or you think about the process, take a step back and evaluate the tools you're using through your hiring process, the accommodations that you may or may not have built in before you get to the flip side of that. I think it's really important if you're introducing new technology or just new resources that you step back and test them out. Maybe have a group of people within your organization test them out to really see if you can identify any opportunities to make it more inclusive, to make it more accommodating for the process, just so you can prevent some unintended consequences down the road.
Yeah, and again, we're happy at Fox to assist with any of these things. I apologize that I have to jump. I know Allison has a lot to talk to you about. But if there's anything that I covered that you want more information on or that you have a question about, feel free to reach out to me. And if for some reason I'm not the right person, I will find you the right person to assist you. So that's with Fox or someplace else. But thank you so much for your attention this morning. And Allison, I'm going to turn it over to you. And I will see you all next time.
Lori, thank you so much for joining us. Good luck with everything today, and we'll see you next time as well.
Thanks.
So as we continue this conversation down the pike around AI, whoops, and I apologize, this deck has a mind of its own today. I don't know how many of you listen to our podcast. Hold on, let me close my door, but we dropped an episode a couple of weeks ago called The AI Whisperer with a fantastic friend of our firm and just a brilliant guy and an expert in AI, John Hack. He's the chief technology officer of a company called Interflection, and he spoke quite a bit about AI. So some of the things I'll share with you today are things that I learned from him. But bottom line is, you're probably dabbling in AI already, but you really have to be ready because it's moving faster than we are. And then, as I mentioned at the beginning of our talk this morning, the return to the office, it still is there. So we're going to do a quick recap and an update on what we're seeing in that space. So just some data on the AI updates. Many of you have heard some of the predictions, some of the forecasts. The Office of Economic Cooperative Development predicts that just under 30% of jobs are at high risk of automation. I think anybody who is walking around with your eyes open and listening, you see this happening in workplaces where certain functions are being automated, and that could be jobs. The World Economic Forum predicted that over the next 5 years, and again, this was last year in 23, over the next 5 years, 25% of jobs will change. That doesn't necessarily be fully automated, but they will change in their focus due to AI being implemented. And interestingly, over 75% of HR leaders believe that they're lagging in organizational success if they don't adopt and implement generative AI in the next 12 to 24 months. Again, if you listen to our podcast, you'll be somewhat astounded at the pace that this is moving. I think we hear about it, but to hear the actual facts around how quickly this is moving. So the time to start dabbling in AI, if you haven't already, is now, and to think about what that can mean for your organization and the tools that are in place. So let's talk a little bit about where we are seeing it supporting organizations. And again, every organization based on your resources, the means, the amount of time and dollars you have are at different places in AI. Most of you are probably using AI within your talent acquisition systems. That's one of the first areas that it really popped into. But where we're seeing enormous movement is in administrative, using AI to expedite certain tasks, almost like a personal assistant. And one of the things that on our podcast we spoke about is really getting that first draft of something. That's where many people struggle, putting pen to paper to map out the beginning of a letter to an employee, or drafting the beginning. We'll talk about training in a moment, but the first draft of training content, or emails or agendas. And this is a place where AI can be an incredible time saver, save you hours. So to be able to pop in, if you use ChatGPT or any of the ones I'll show you in just a moment, to pop in your keywords or write your first kind of schematic draft and then put it into the system to be able to give you a first draft. Reminder, and everyone knows this, this is not you are responsible for proofing the information that comes through, and you cannot rely on the data that you receive to be 100% factual. AI operates based on language. So what it does is it synthesizes words through millions of documents available on the open access, and it will pull together what it seems to make sense. And it still is a work in progress. So it could string together things that maybe are not factually true. So at the end of the day, whatever you do use, you own having to proof it. And that's an important piece of this, and make sure your data is accurate. But that can be a huge time saver. Professionalizing language. So if you have a letter or a document and you feel like you want somebody to kind of proof it, or you want it to just feel as though it's more professionally written, you can drop it into AI and get back in seconds a more professionalized language. If it comes back too professional, if it comes back sounding like it's not really your voice and you want it to be more friendly, you can pop it back in. And then again, it's just a time saver. You can edit to make sure it's your voice and it sounds like it's coming from you. But that's another way to do it. Obviously, the free versions, all AI, you have to be open to, because you would never want to drop confidential information into a draft or any proprietary information. Um, the 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 free versions are even more open than the paid for version. So just be aware, if you dabble around, do it with things that are not sensitive in nature. And certainly if you begin to introduce this to staff, then you want to make sure that you are, and we'll talk about that in a moment, is crafting policies around what can and can't be subject to AI. Where we do see AI being used quite well and really effectively is around training content. So basic training content. When I recorded the podcast a few weeks ago, one of my colleagues was a co-host with me and was inspired to really try out AI after the presentation, and spent the next 48 hours somewhat obsessed with trying a product called Claude and just creating from scratch a training program. And he said what would have taken him days to complete, he had a first draft with a PowerPoint and had the ability to do a voiceover, if he had chosen to, of that PowerPoint in the matter of an hour or so. That's including his editing time of what he received back. So that's one area in your organizations. If you have to pull together training content quickly on something, that's a way that you could use it. Canva is one of the sources that is good. Again, I'll show you on another slide some of the tools that we're seeing being used. Certainly not an all-inclusive list. First drafts of presentations. Again, first draft. Remember, these are drafts. You're responsible for checking the data. Make sure when it comes to training or anything that you're putting out there as content from your organization, that you make sure that you're not using copyrighted information, et cetera. You want to make sure that you're checking any material facts and for plagiarism reasons and things, that you're really being diligent about reading that proof. So make sure you update your data for accuracy. A great place where this can be helpful is for generation of ideas. If you are working on creating something new and you're looking on where to get started, start with one of the AI resources to plug in a few keywords or some thoughts, or what is it you're trying to look for, and you can come up with some generated ideas. Yesterday, I was recording another podcast with a guest, and she shared that just to prompt her thinking around the topic, she popped some things into ChatGPT just to begin to help her frame her thinking of what seems to be out there? What are people thinking about, and what would be relevant to the audience? Research on HR topics, issues, trends, policies. Those are places where you can really begin to leverage AI for time-saving purposes, and your staff as well, again, with certain parameters. One of the things I learned about AI in talking with our guest on the topic, our AI whisperer, is that AI has not yet been programmed to show empathy. I thought that was very interesting. And whether or not it will be able to develop that as it is AI learns on its own, is the jury's out on that. So keep it human. Whatever you're using AI for, make sure that you're being the rational human element, because the system will not do that. So these are just some basic ideas on how you may be able to incorporate it with your teams today. Some of the tools that we see out there, again, this is not an all-inclusive list. You'll see they're popping up every day. If you do a search right now, you're going to see hundreds of AI tools. And some of the things that you're probably familiar with are tools that are already embedded in your online banking and the bots that answer all your questions, because you can't talk to anybody live anymore. They have AI as the first level of customer service responding to your requests. Again, we'll be sending this out with the recording, this deck with the recording of the presentation. So you'll have all of this on there to look at. So bottom line, for you to get ready and start planning, you should really familiarize yourself. If you haven't already dabbled there, try it out. Set up a free Chat GPT account and start playing around with it. As I mentioned, my colleague used Claude, number of different ones, but just see what its capabilities are. If for anything else, it will be on your own personal assistant and will save you hours in the course of a week. Take a course. There are a number of free courses. You can look at LinkedIn. There's some paid courses, but take a course to be able to begin to navigate and understand what the risks that are involved, but educate yourself. This is moving way too fast for everyone who's listening right now to not take that first step. And just a reminder again, open access, be aware. You want to make sure if you're doing this for your own purposes, but even in the business setting, that you are very clear that you will not put proprietary or confidential information into the system. Some of you who may be in more regulated industries, you want to make sure that you don't put anything that would jeopardize access to personally identifiable information and all of those good things. Prioritize AI literacy in your organization. I mean, encourage those that work with you, other HR professionals, really get educated on what it means. One of the things that was recommended, and I think that this is a great place to start, is to pull together an internal team of cross-functional individuals to begin to explore ways that you might be able to leverage AI in your organization. And it's important that it be a cross-functional team. So you can have your technology people, maybe your finance people, maybe your marketing people, and HR, but different ways that people in your organization may be able to implement or gain from having AI. MIT came out with a really interesting study, by the way, that looked at the effectiveness in AI in supporting people's performance. And interestingly, they looked at what they concluded, among many other things, and you can go online and look at for this study, is that the biggest benefit for or the biggest gain from AI were for those with the least amount of experience in your organization. So think about new employees, think about people who might not be new to your organization, but might be new to a particular role. That's a place where you can look at how AI may be able to get them up to speed more quickly. It did show benefits for people who were more experienced, but it was not as the percentage was not as high. So just food for thought. There are webinars, podcasts, seminars. Talk with peer groups. Those of you that are in industries and have industry groups that you connect with, and you're not in you're always competing, but not in too much of a competitive space. Talk with those peer groups, talk with other HR people or business leaders to see how they're using AI in their organizations. Stay on top of the trends for sure. And just reading, and Wall Street Journal is always a great resource for what you're seeing in AI. And then a big to do for everyone is maintain a learning mindset. There are going to be bumps with AI. Some bumps might be bigger than others. And that growth mindset, that learning mindset, where somebody does take the initiative under your guidance or within the parameters that you've set forth for them to work within. And there is a misstep or something, make sure that that it's not punitive, that you actually help people learn from that and move in a different direction. And then if Lori were on, she'd be talking about crafting policies around this. This is an evolving area of the law, so you want to make sure that if you start crafting policies around AI, they're going to have to be reset regularly as AI continues to evolve and the capabilities grow, but make sure you have policies in place to manage the use of AI. Back to the office. Again, I mentioned that this is going to be a bit of a recap, but interestingly, last we spoke about this was in September, and not a lot has changed. We still see people choosing from 3 different workplace models, with hybrid being the majority. This list was added to since the last time, but I think you've probably heard since the close of last year, the beginning of 24. Now we're hearing 2024 is the year. By the end of 2024, what stat did change is 90% of employers want staff back in the office by the end of 24. Last we did this, it was 80%. So that has increased about 10%. The only about 20% of employees support this. That number has not changed. That seems to be holding steady there. And this does not mean that they want people back 100% 5 days a week in the office, but they do want people back in the office. 72% of companies have mandates regarding return to the office. Some of those do include up to and including termination. There's a term that is popping up now, you may have heard of, is you've heard of quiet quitting, right? On the employee side, quiet firing is a term that has popped up now as organizations are looking to right size themselves. And in some cases, and I'm not saying this is the primary reason, but as employers put these mandates back in that you have to come back or else that may lead to termination, that's one way as they're thinking about reducing that, for those who fail to return, then just through attrition, that they will reduce their workforce. Office occupancy is still hovering around 50%. And only 19% of employers are saying that they would require 5 days. So what we're mostly seeing, and this has held true for, 2 years now, about 70% of employers are looking at a 2 days in the office, 3 days home, or 3 days in the office, 2 at home, with Mondays and Fridays being the most popular at-home days for obvious reasons. And then also making sure that the consecutive days gives people, some people report that it's easier for them to align things like childcare, et cetera. Interestingly, there's been some updated research from LinkedIn and other organizations, but this data at the bottom is pulled from LinkedIn, that companies who have required return to the office are reporting improvements in the following areas. So they're saying revenue, productivity, 80% worker retention, 60% employee relationships, and company culture, right? So I think what's important here is how you implement the return to the office is going to impact these numbers for your organization. Remember, people have been working at home for a long time, so obviously they need time to be able to put plans in place for childcare coverage, which is not as abundant as it had been in the past. They're struggling with staffing issues, so it can be a little bit complicated for people to find childcare coverage. So you want to make sure you give them time for that. And then also think about, and this is interesting, our group was back in the office. Our employees have asked us to come back to the office once a month, just so we have a chance to be together, which we think is wonderful. We're a remote first organization. And so we had everybody back in the office. And what was interesting, and the whole team was saying this, is you have to relearn how to work in an office when you're used to working in your own home office with your own uh, style of work, whether that be complete silence, no music, no nothing in the background, versus a constant steady of voices or other noises that could be distracting to you, or a work environment where you're seeing other people where you're not used to that. So you really have to be intentional about uh, giving people some time and thinking about how to minimize some of the distractions that they may be feeling now that they're coming back from 2 years of working on their own and going back into the office. We did talk about this the last time we spoke, and make sure you're clear on the why. Why are you having people come back to the office? Your why is going to be different from my why, from somebody else's why. But employees want to know, they want transparency. They want to know, why is it that after all these years, you're bringing us back into the office? So whatever your reason may be, make sure you're clear about it. We have had a number of asks about people who allowed individuals to relocate out of the area, and now they are saying, those of you within 50-mile radius, 60-mile radius, 75-mile radius have to come into the office X number of days per week. Be very intentional about what that means for people who have located outside of the area and how that's going to impact their ability to get into the office. Pay practices, we spoke about this last time as well. If you are going to allow people to remain out of the office but come in on certain days, how is that going to impact any geography-based pay? And then also manage the flexible work models, workplace burnout, be very realistic about expectations. We have seen an uptick in accommodation requests for organizations that have been mandating a return to the office. And the accommodation requests have been to either not come back to the office, not come back to the office as many days as the employer is requiring. And the reasonings behind that are around stress or anxiety, different issues. Make sure you take those seriously, just as you would any other accommodation request, and that you have a process in place to evaluate those accommodations and make a business decision as to how you're going to respond. Remember, with any accommodation request, you do have the right as an employer to reassess the need, 3 months down the road, 4 months down, 6 months down the road. But you want to make sure that you are taking those requests and running them through an objective process. The reason I say that is, you might think, well, they were able to come into the office before, and now they're not able to. There have been, because of people's isolation or not driving as much as they used to, or just the stress of balancing work and life, the mental health issues that have developed are very real. And I want to make sure that people really take that seriously and recognize that it's not as easy for everybody to just make the switch to come back. And then certainly experience parity. This is something we've even experienced in our new back to the office once a month. We have a few individuals that are outside of the area and would not be in the office. And our technology is good, but we are not learning, we haven't mastered how to use it effectively in order to make sure that people who are dialing in for our in-person days have good access and good sound and access to the tools and resources. So make sure that you're thinking about that as you begin to bring people back to the office. Just real quickly, transparency is key. Transparency is key in with all employees today. That's one of the number one factors that impact satisfaction and employee engagement right now, is how transparent. Transparency is a scale. It's going to be different from all of you, but you can be transparent with certain things. You can be transparent with your why, for why you're asking people to come back, the reason on the return to the office, making sure you're clear about the guidelines or mandates that you're going to manage them. I have Google in here. This is from the last time we presented this. They have said, if you do not return to work, then you may lose your job. That's one of the organizations that has put that out there. Amazon has as well for certain levels of the organization. Make sure you're focusing on what that employee experience is going to be when people do come back, and then plan for those expected and unexpected consequences. Just be ready to bob and weave and respond and make course corrections when you start going the path. The other thing I do want to add here is consistency. If you're going to require people to come back, and we've seen this quite a bit, throughout your organization, you have to be consistent across departments, across functional areas. If you're requiring people to come in, call it 2 days a week, 3 days a week, that's being applied across the organization for similar jobs, because that's a very quick way to really impact employee engagement. If certain departments are holding people accountable and other departments are not. So you have to make sure your managers, your leaders are aligned, and that you're prepared to practice consistency across the organization. So just a couple of parting thoughts before we let you go today. AI, make sure you educate yourself and others. The return to the office, I just went through some of the do's and don'ts. Make sure you define the why, what, when, how, who clearly, regularly, not just once and done. Craft a communication plan as to throughout the process, so that you know when you're going to make that mandate, what the time frame is, who to go to if people have questions, all of the key questions that someone will want, and make sure your managers are well educated around that plan, and also around the reasons behind the why, what, when, how. Remain flexible and allow for a regular check-in process. Check in with people when they're coming back. One-on-ones. You do this, likely you do this anyway. If you don't, it's a good best practice. But as people start coming back in, check in. You can use surveys, etc. But there's nothing that's as valuable as a real check-in process, face-to-face check-in process. And then train managers on leading effectively, regardless of what type of work environment you have. As we always say, update your handbooks, check your handbooks, look at your policies, look at the rules, look at your severance agreements based on some of the things you heard from Lori today. Look at all of your legal documents as it relates to HR. Train your supervisors on unfair labor practices. Make sure that they're aware of what constitutes an unfair labor practice, and what to look or listen for that might be signs of organizing, and other activities or things that are just making employees not feel included or welcomed. And lastly, I just want to thank you all. Let me just see if there are any questions there for joining today. We hope that you take a little nugget away of something of value. Lori and I will be back in a couple of months to give you some more updates. But certainly in the meantime, if there are any questions or if there's anything we can address for you, please don't hesitate to reach out to either one of us. We thank you for joining our first 2024 webinar of I'm just checking here. I was going to say, hold on, let me close my door. Of the Morning Blend. Thank you, everyone, and have a fantastic week.